we get started, I'm just going to place my objection on the record that this is being handled.
That this is being handled?
Yes, especially in front of the media in the middle of a trial, when this is obviously very likely going to be put out in the public, Your Honor.
Well, I do have a concern about that.
Hey everyone, welcome back to J is for Justice. You may remember, if you watched the James Crumbley trial with us, that there was this hush-hush secret motion that the prosecution was going to bring in on the record regarding James Crumbley and some jailhouse calls and threats. We now know the subject of his threats, but before we get into that, let's watch that clip of when this all went down in court.
Judge, I was not certainly asking for it to be in front of the media, but I don't know how to make a record without that.
Well, we've learned that. It's called 8.1 amendment.
May I, Judge?
Well, I guess I'm wondering during the course of the trial if there's any kind of a stipulation that could be agreed to.
Certainly, I'm happy to discuss what my request is, Judge.
Well, Ms. Lehman, would you be willing to have a discussion with the prosecutor's office? I can't, I have to hold public courtroom.
Correct, Your Honor.
I do not want to impact your client or your case in any way by doing so. So I'm weighing the rights of the parties. So
I would be more than happy to speak with the prosecutor's office about this.
Judge, I'm going to be very brief.
I think the situation could be temporarily taken care of with a stipulated order, but I don't know if that's satisfactory or not. I'm reluctant to impact the rights of the parties during the jury trial.
I mean, Judge, my request is pretty straightforward, and it's pretty time limited.
Well, I know what your request is, but I'm concerned about statements that might be placed on the record, right? Aren't I concerned about that?
I am, Your Honor.
I mean, Judge, I think it's appropriate for the record, and obviously the jury's not present, that's why they're not here. But I understand what the court's raising. I'm not.
All right. Well, I know you do. I know you do. I know you understand my concerns as well.
I do.
You could, Your Honor.
In fact, Judge, I think we'd be willing to have the order expire by its own terms upon a verdict. We're just talking about during the pendency of the trial.
Okay. If I'm shaking his head,
At this point, we find out that they are trying to restrict James Crumbley's communications while he's in the county jail during trial to only clergy and his lawyer. And James Crumbley is not agreeing to this.
Judge, I'm happy to do that.
Okay, Your Honor, my client is not willing to agree to the order.
Okay, so
It's basically restricting his ability to speak to people, Judge. I mean, it's a complete revocation, except for counsel.
I'm most concerned about him being able to talk to you.
Right, and absolutely that's not part of what we're asking. I mean, Judge, if the order gets entered, we're asking that the communications be limited to only counsel and legitimate clergy during the rest of the trial. That's my request. We're talking 7 or 8 days. You can talk to his attorney, you can talk to legitimate clergy.
Okay, so if he doesn't agree to it, then the prosecutor is going to make their motion. Right?
And I have advised Mr. Crumbley of that, Your Honor. I would propose that there could be a different order with a restriction and not a complete revocation. Obviously, the prosecutor's office is reviewing communications. They would know whether or not the order was violated, and at that point, if the court needed to take action, then the court could take action.
Judge, it's not just about violations going forward, it's about the conduct that's already happened.
Well, I understand that. I understand that. It's so hard to understand because there's a big old sign right there, right?
It's on every call. Every single call.
Yeah, I'm
Judge, if there's not an agreement, I'd like to just make my motion. It's fairly brief, Judge.
So, Ms. Liner, what's his position?
Your Honor, he is not agreeing to the order.
Okay, well, does he know that in 10 minutes there's going to be an article about it? you know, and 10, maybe 8. I can't, I'm not permitted to have a closed courtroom unless we're proceeding with a closed hearing under 8.119, and as I sit here right now, I don't know if this qualifies, so.
No, you won't. May I speak with Mr. Williams for 1 month?
Yeah, you can step out if you need to.
Yes. Should we wait? I think I should.
That's fine.
Okay. Do you want me to bring it in?
Yeah.
Okay.
Judge, I think we reached a resolution.
Sounds good.
Judge, I think I can just briefly make a record. This is obviously, the order is going to become public. The agreement is going to be that Mr. Crumbley's communications will be revoked, but not his ability to do research or otherwise participate in his own defense. So not just communicating with counsel, but his ability to read or get other information.
Okay.
Simply communication.
And
So-
that's going to be a stipulated order between you and Ms. Lehman.
Correct.
All right, and did you say that that order would expire upon a verdict?
Yes, Judge.
Okay.
And perhaps it should go
what if there
without
isn't
saying.
one? What if there isn't one?
Well, I think,
Could you
I
let,
mean, we can address it at the time.
Okay.
I think the issue is, once there's a verdict, a lot of the issues just fall away.
okay.
And Judge, it should go without saying, but I hope the court will encourage Mr. Crumbley that the conduct that's got us here.
I think I already did through his attorney
Okay,
on several
thank you.
occasions, both in private meetings that we've conducted. And I say private, I mean with both the prosecution and the defense.
And for the record, I've also addressed it here.
I know you have. So. I gave out free legal advice, Mr. Williams. So someone can take it or not take it, right? So I'll sign a stipulated order.
So, pretty wild interaction in court, right? Well, we have coming out yesterday, March 18th, via the Detroit Free Press, the following information. Before going to trial, James Crumbley threatened Oakland County Prosecutor Karen McDonald in jail communications with his sister. Specifically, the now convicted father went off to his sister about how he was going to make it his goal in life to destroy McDonald. According to a source close to the prosecutor's office, the threats included James Crumbley allegedly saying things like, "She was going to hell soon. She better be scared," and "she was done." These alleged threats occurred in multiple phone calls, dating back to 2022, though the most recent occurred in 2023, months before Crumbley's trial started. Why it wasn't brought up before that point in the trial, we don't know. No criminal charges have been filed in connection with the incidents, and the Oakland County Prosecutor's Office declined to comment. Unbelievable that he is threatening the prosecutor on recorded jail calls. And here's a photo of James caught in the courtroom, shooting a glance at Assistant Oakland County Prosecutor Joseph Shada as he exited the Oakland County courtroom on Wednesday, February 21st, 2024. James Crumbley was convicted on 4 counts of involuntary manslaughter after his son was the perpetrator in a mass shooting at Oxford High School, killing 4 students. His wife, Jennifer, was also found guilty on all 4 counts. Their sentencing will be April 9th of 2024, and we will stream it here at J is for Justice. Make sure you're subscribed and click the like button if you liked this video. Let's keep the conversation going in the comment section below. Let me know what you think of these threats that came out of the jailhouse calls of James Crumbley. Be sure to check out my other videos and playlists for more true crime content. And if that's not enough, you can join our Patreon. Don't have a tinfoil hat? It's okay. We'll make you one. It's that easy. See you guys in the next video.
See you later. Bye.